A very good afternoon to everyone present here. We have another episode of Policy to Practice podcast, which is a podcast for the Center for Development Policy and Practice. A little about Center for Development Policy and Practice. It's an independent research organization working to influence public policy with a focus on the development of vulnerable population. This certain series of podcast is under CLES, which is the Center for Law, Economics and Society. This center is dedicated to conducting comprehensive research on the Indian legal system and access to justice, with a particular focus on how it affects the vulnerable population who are accused of crimes. In this episode, we want to dive into the critical question of how minorities are treated or mistreated in the context of the India's criminal justice system. Our guest today, we have Professor Manisha Sethi, who is a renowned sociologist whose work focuses on religion, law, and majoritarianism. Her research has covered a wide range of topics, including gender, politics, and counterterrorism. She is the author of Kafkaland, as well as Escaping the World, both offering deep insights into law, society, and faith. Now, I would request Professor Manisha to give a brief introduction about herself, which is more current. Ma'am, over to you.
No, there's no need for introduction, I think.
Okay, ma'am. So we'll start with our first section, which would be on law and majoritarianism. So, ma'am, how do you see the relationship between India's minority or the marginalized group more generally and the legal system here in India?
Yeah, so see, when we talk about the criminal law, we tend to think of criminal law as a space which is very abstract, which is very rational, which doesn't sort of differentiate between people as groups, right? We tend to think of personal laws as the domain where religion is present, but criminal law is something which is really, which is totally abstract and individualistic. Now, however, when we look at the way in which the criminal system actually works, and even, the letter of the law. So, when we talk about the fact that there are more, certain groups of or categories of people, we tend to say, okay, there is, the vulnerable communities have no access to legal system, or they do not have access to good lawyers, or that there is so much pendency in the court, so therefore it takes a long time just to finish a trial, and so therefore people are incarcerated for long years. We don't really question the way in which criminal law itself is framed, right? We tend to think of it as something which is above questioning, or certainly something which is very abstract. So now what I want to point to is also the fact that criminal law itself is a site where religious differences marked and constituted, actually, right? Not simply by the formal letter of the law, but really, I'm an ethnographer and a sociologist, so the way in which law actually works, right? So now, if you talk to Muslims in Muslim mohallas and neighborhoods and so on, it's quite a common complaint that there are more police stations or more police personnel in the mohalla than there are hospitals or schools or the other sort of provisions that any welfare government would make, right? So the idea that Muslims experience the state more through the heavy hand of police than through its welfareism or through its other sort of provision activities speaks a lot, right? And if one were to look at it in terms of the different localized institutions of the criminal justice system, the first is, of course, the police, right? Now, police, if you look at the constitution of the police, firstly, is the fact that our policing system is deeply colonial, right? The antecedents of the Indian police system lie actually in the Irish Constabulary, where the British needed to maintain a very hard sort of control over, the Irish subversives, so-called, and so on. So it was primarily meant, based on that Irish model, it was meant as a force which would enforce order, right? Which would so the law part was a little bit behind, but creating order or maintaining order by keeping a tab on what the colonial government thought was subversives or recalcitrant populations and so on. So it was from the very start a very harsh model, right? a model based on surveillance, model based on preventive detention, and a lot of these continue onto the present day. And in fact, even though at that time the British were very, in terms of Macaulay's penal code and the policing, there was these pretensions to universality that what we are giving you is a very sophisticated universal legal system, right? And yet we had laws like, say, the criminal tribe law, right? Which really, cast suspicion on entire communities. So all of those legacies have continued into the post-colonial system. So we have a policing mechanism which is heavily influenced by that model, right? But if we look at the police force itself, we find that it's not a very diverse force, right? In terms of representation of marginalized groups, it's very, very, in fact, not diverse at all, right? So if you look at Muslim representation, it's consistently hovered below 3 to 4%, which is very low as compared to what is the population and the share of Muslims in general population, right? So even the SC/ST population is quite low, but the fact that, but that sort of indicates that the positions have not been filled because there is reservation, right? Now there is no reservation, or there will be no reservation for Muslims. So the possibility that these numbers will rise also remains very bleak, right? Now, it's interesting that from 2014 onwards, these figures are no longer available, right? The data which was there earlier, which showed you the numbers, the community breakup of the police forces. So you don't have number of Muslims in police force after 2014 by the NCRB at all. Now, in striking contrast to these very low, feeble numbers of Muslims in police force, what we have is swelling ranks of Muslims in the jails. Right, you have what is called incarcerations, right? So quite disproportionate to their numbers in general population. You have a huge number of Muslims in jail. Now, so I have some interesting data here. So in 2018, for example, Muslims were 20% of the under trial population, right? And 16% of the convicted. Now, by 2021, 3 years, so between 2018 and 2021, 3 years, the number of under trial prisoners had risen to 30%. So there's a 10% increase in the number of Muslim under trials in prisons, right? Now, I mean, if one were to look at the different states, the story becomes even more complex. So, for example, in Assam, around 47% of convicts are Muslims, and close to 53% are Muslims, whereas the share in population is simply only 34%. Right? It's a proper horror story when you look at the number of detainees, the figure of detainees. Now, detainees are those who are held lawfully in custody. So people who are under different kinds of preventive detentions, NSA, etc., etc. In 2021, the percentage of Muslim detainees at an all India level was 27.7%, double their share in population, right? Again, in Haryana, for example, where the percentage of Muslim population is only 7%, it was 100%. So all the detainees under preventive detention in Haryana were Muslims, right? So what you have is, on the one hand, very low representation of Muslims in the police force and very high numbers in jails, right? So which points to the way, the institutionalized nature of prejudice that ails our criminal justice system. Now, interestingly, in 2013, the Director General of Police of 3 states, Maharashtra, Uttar Pradesh, and Tamil Nadu, they submitted a report to the central government about the perceptions, or rather the relationship between minorities, mainly Muslims, and the police force. And they said that there was a huge gulf between them. And a large number of Muslims perceived the police force as biased, right? Now, so that's one part, that the people feeling that the police is biased against them, right? Now, there's an NGO called Common Cause, which does these surveys on policing. And in 2018, they'd done a survey of police personnel about their perceptions of Muslims, right? Now, very interesting data comes out of that. Interesting, but also very tragic. Which said that, so the Common Cause survey found that 14% of the police personnel feel that Muslims are very much naturally prone to committing crimes, right? And 36% feel that Muslims are somewhat naturally prone to committing crimes. So almost 50% of the police personnel, which feel, of those surveyed, felt that Muslims had a very somewhat greater natural affinity to crime. So now you can only guess, when a crime occurs, who will be their most sort of natural suspect to start their inquiries. So this was a survey which was done of the lower ranks of the police. But it is not as though it is only the lower ranks which, are assailed by the sense of, bias or prejudice. Uh, there is this Mr. Prakash Singh, who is the former DGP of BSF, and who is uh, who is consistently, in fact, I mean, he's the poster boy of policing reforms. And by reforms, he basically means that police should be free of the fetters of, it should be freed of political influence. It doesn't mean more accountability, or doesn't mean more equity or more justice within the policing system. Now, he says and this is many years ago, in fact, when I think there was some controversy around such a committee producing these, numbers of Muslims in prisons. So he was asked for his opinion, and he said that, you know, I mean, it's really not a question about disproportionately high number of Muslims lodged in jails. He says that in cases of, and I'm quoting him, in cases of terror attacks or communal riots, if the police goes after the perpetrators of the violence and they happen to be mostly Muslim, you cannot, in the name of secularism, expect the police to act in proportion to their population. So he is himself, under the same sort of prejudiced approach that the Common Cause survey shows us, that they are naturally, there is a greater affinity of these people to be perpetrators or criminals, right? Now, interestingly, when Yogi Adityanath took over as the chief minister of Uttar Pradesh, and he started a wholesale, policy of encounter killings, right? It's a stated policy of the government. Though is the stated policy of the government. So, and who are the people who are being killed? They are largely Muslims, OBCs, Yadavs, and Dalits. So that's the kind of there have been studies on that. So he said that, in his justification. So now, of course, his whole idea about freeing the police from political fetters is out of the window. And he says, and he hailed that policy and said, that certain sections, again, pointing to the way in which, the policing mind is working here, that certain sections had been allowed to run amok during previous regimes, meaning during the BSP, during the SP regime, which were set to represent certain sections who had been, the marginalized sections, right? So certain sections had been allowed to run amok in these previous regimes. And so now, Yogi was only correcting it because the criminals largely came from those groups, right? So this is the kind of logic, which circulates very commonsensically, right? In a larger society, that there are certain groups who are more inclined to criminality, and that criminals are fair games for encounter killings. Terrorists are even better, of course. And since guilt, so you're apportioning guilt by association. You're saying that certain sections of people are, more inclined to criminality. So it's all right as long as those encountered or those killed or those in jails uh, follow, or belong to certain groups. It's all right. You would think of it as a fair game, right? So there is this existence of bias and, at the heart of policing, which has been recognized. It's not as though it's not been recognized, or activists have been talking about it only. From the earliest of times, for example, commissions of inquiries looking into, communal violence, mass communal violence, have indicated this. They've pointed to this. Many commissions of inquiries have pointed to the fact that police either ignores the calls of minority communities, when they're beleaguered by or surrounded by mobs of, majoritarian mobs, or they have actually participated or colluded with them, right? So all of this is there. I don't know, you will be too young, but, so some of the others will remember the famous slogan by rioting mobs, especially in UP, etc., where "Ye andar ki baat hai, police hamare saath hai." When rioting, rampaging mobs would go to inflict violence on minority groups, this would be the slogan that they would raise, knowing that they would have the patronage of the side of the police, right? So this is a pattern which has been found many times, and in fact, very little seems to have changed. Earliest of commissions of inquiry, for example, in 1970, the Maidon Inquiry Commission, which was instituted to look into the riots in Bhiwandi, it noted that the police actually encouraged, and I'm quoting from the Maidon Commission, which says that the police encouraged the processionists in their misbehavior and led them to believe that either the police were powerless to stop them or were on their side, right? But more acerbic and I think more relevant for us here is the fact that the Maidon Commission notices that there was a special inquiry, SIT, which was instituted to look into the riot cases. And what it did was it colluded with the majoritarian groups and in fact filed cases against the members of the minority community. And this is something that we've seen in 2020 as well in Delhi. After the riots, post-CAA movement, cases were filed large scale against Muslims, basically, right? Even under UAPA, right? So I'll leave it at that, just to sort of give you a kind of broad overview of the kind of prejudice that exists from the upper echelons of the police bureaucracy to the lowest, levels.
Thank you so much, ma'am. Ma'am, you mentioned about the Unlawful Activities Prevention Act, right? Which is often criticized for disproportionately targeting the Muslims and the marginalized groups. So, similar criticisms have been for the laws which came before it, such as the Terrorist and Disruptive Activity, as well as the Preventive Terrorism Act, POTA, following which they were repealed. So, why are these laws like this that it's so prone to being misused?
See, I think what these laws do, whether it's TADA and then POTA and what UAPA, they do sort of two things, right? Uh, or rather three things, I would say. The first is they create new categories of crimes, which did not exist in criminal law earlier, right? So you have a terrorist act, right? Or unlawful activity as in UAPA, right? And raising funds for terrorism, financial terrorism. So over a period of time, as these laws get amended, newer and newer categories come to accrete into it, right? Now, and the definitions have continuously expanded, right? So, for example, the Terrorist Act in 2004, when UAPA was amended, the definition of terrorist act became even more expansive, and it said disruption to services essential to the life of the community, or by using any. So the earlier definition of terrorist act said by use of, some kind of, violent means like bombs, pistols, whatever, knives. And so it listed a whole range of things which constituted violence. But then in 2004, it said by using any means for whatever nature, which basically said, even if you're not using violence, then you could be still engaging in a terrorist act, right? So what it does first is it creates new categories of crimes, and that these definitions, are, we've seen, very imprecise, very vague, very loose, elastic definitions, which and very sweeping, right? So which allows many kinds of activities, which are basically political activities, right? For example, giving a speech against the CAA, right? That could constitute a terrorist act. In fact, all of these people, Umar and Sharjeel, etc., are in jail under UAPA, right? So, so it could include non-violent political activity within its ambit. So it renders a whole range of, non-violent activities such as human rights work, political work, uh, dissent, whatever you may, say. Uh, it opens it up to malicious prosecution just by the way in which these definitions are made. Very, 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 very vague, very broad. So disruption to essential services. If you're doing chakka jam, you're blocking a road, which means you're not allowing buses to pass. So, or industrial strikes. So workers, if they go on strike, it could mean a disruption to essential services, right? And that could invoke charges of terrorism, right? So that's one thing. And also these definitions include many things which are already included under ordinary criminal law, right? So for example, counterfeit currency. Now, since the amendment in 2011, I think, in UAPA, counterfeit currency, making production and circulation of counterfeit currency is a terror act, right? But it's also under ordinary criminal law. So now what it does is it gives so the police has the power to decide now whether to book your case against you in under UAPA or under ordinary criminal law, right? So the duplication of crimes then gives this so much subjective power to the executive to decide which law to invoke, right? And it's no surprise as to when they are invoking which law, right? Again, against who, which people, right? So that's one thing. And again, if you look at the definition of unlawful activity,
Sure.
bringing about or supporting secession, disclaiming, questioning, or intending to disrupt the sovereignty and territorial integrity of India, even questioning, or causing or intending to cause disaffection through acts or by words, either spoken or written, or by signs or by visible representation or otherwise. So poetry, art, so and any activity, can be consigned to the dustbin of unlawfulness, right,
Mm.
by the state, depending on, who you are and which category you fall into, right? So that's the first thing. They create new crime, they create new categories of crime, but leave the definition so wide, so broad. Anything can be construed as terrorist, anything can be construed as unlawful, right? Secondly, they depart from ordinary criminal law, right? So they are some kinds of safeguards, and they've been hard-won safeguards, right? To ensure that the liberties and the rights of those accused are, protected even in a criminal trial. So the natural principle of justice is that you are innocent until proved guilty, right? And the process, it's the burden of the prosecution to prove you guilty. Now, what happens here is that it departs from ordinary criminal procedures, right? So, for example, in TADA, if you look at TADA, it allowed for the admission of confessions, right, made before police officers. Now, which it added new offenses to terrorism. It introduced summary trials, secret witnesses. Then POTA allowed for interception of electronic communication, etc., etc. So all of these, they depart from criminal law as we understand it ordinarily, right, which gives us the benefit of protection, right? So those protections are taken away. So UAPA, minus the admissibility of confessions, which was there in TADA and POTA, it is basically a replica of both TADA and POTA, right? So what it does is and the fact we'll talk about so these are the two things it does primarily. Firstly, it creates these new definitions which are very vague, imprecise, giving a degree of subjective power to these executive. And secondly, it departs from ordinary criminal trial as we understand it, right? Now, the question of bias, which you mentioned, right? If it's been well documented, so it's not just me saying something, but it's been well documented, and that is why the question as to why, when we repeal TADA, we've let POTA lapse, right? Both of these laws have been taken away from our statute books, with the knowledge that they were being used systematically against minorities. Why is it that they prove to be so attractive to governments, right? So and I think that's the question of bias here, because if you look at the implicit usefulness of laws, like, so we often say about the misuse of anti-terror laws, but there is no misuse. That is precisely the use that it's meant for, to use it as a tool to quell dissent, to use it as a tool to criminalize certain categories and groups of people. And there is substantive evidence to show that this is in fact exactly what happened, right? So in TADA, of course, during the Punjab insurgency years, there were thousands of people, virtually all Sikhs, who were in jail for many years, right? Although in the end, a large number of them were acquitted, right? But statistics actually show that by 1994, Gujarat had arrested 19,000 people under TADA, right? So TADA was initially meant to be for areas which were disturbed areas, right? That's Disturbed Areas Act, right? So, but it quickly spread out because all the governments found it very useful to use it against people who were descending farmers, who were agitating, workers who were agitating, students who were agitating, Muslims, Sikhs, So, and in the National Commission of Minorities, actually, in 1994, documented that 409 out of 432 arrested in TADA in Rajasthan belong to minority groups. So a large number of the burden of, these laws were falling on people who came from marginalized groups. So what's happening here? You're just criminalizing a group of people, whether it's an ideological group in the case of Bhima Koregaon, and in the case of Delhi, very clearly a religious group. So you're criminalizing them for a long time. The intention may or may not be to secure conviction. The intention is to keep them in jail for a long time, to serve as a lesson for others as well, right? So these are basically preventive detention laws, which keep within the pale of criminality groups of people, whether ideological or socio-religious groups, and therefore, in that sense, work very much like the Criminal Tribes Act, which is, sort of imprinting your body with the mark of suspicion, right? So it is both of these, the definitions and shortcuts, which and the fact that because they're so arbitrary, because of duplication, because of the very huge expansive powers given to police and executive, that the executive can actually turn people, groups, ideologies into enemies of the state. So that's basically what's happening with these laws. Yeah.